Good afternoon, everyone, and welcome to the investiture of Professor Ralph Brubaker as the inaugural Carl L. Vacchetta Professor of Law. Investitures are a time-honored tradition used throughout history to confer on their honorees the authority and prestige of high political, religious, or academic office. In the setting of a world-class research university, such as the University of Illinois, investiture in an endowed position acknowledges the highest accomplishment of a faculty member. As his record amply demonstrates, Ralph Brubaker has shown the exceptional achievement that is required of an endowed faculty appointment, and today we celebrate that achievement. Celebrations are family affairs, and we are delighted to welcome members of Ralph's family, his wife, Rhonda, their children, daughter Allie and son Clinton. The triplets, by the way, could not make it today, but they send their congratulations to Dad. His mother, Frances, his father-in-law, Stanley Bainey, and his mother-in-law, Patsy Arnold, and his brother, Brad Brubaker. Welcome. In addition to celebrating the work of the honored faculty member, investitures provide an opportunity to honor donors whose vision and generosity make these events possible. Carl Vacchetta is a longtime supporter of both the University of Illinois and the College of Law. Now senior counsel at DLA Piper as part of a long and storied career at that firm, Carl graduated magna cum laude from the University of Illinois College of Business in 1963 and from the College of Law in 1965. He is a member of the college's Dean's Advisory Board and serves on the Board of Directors of the University of Illinois Foundation. Carl's financial generosity has been boundless. In addition to funding this professorship, he is a founding member of the John E. Cribbett Society, was the co-chair of the college's $50 million Brilliant Futures Capital Campaign, partnered with the class of 1996 for the first class endowment gift, and established the Carl L. Vacchetta Scholarship in Law. With the help of his firm, he endowed the Vacchetta DLA Piper Lecture Series on the role of government and the law, which has brought to the college some of the nation's most distinguished leaders, including yesterday's speaker, the EEOC Commissioner, Kai Feldblum. In recognition of his support, Carl was the 2003 recipient of the university's prestigious William E. Winter Award for Outstanding Advocate Leadership, and in 2013, he was inducted as an inaugural member of the University of Illinois Army ROTC Hall of Fame. I've known Carl for many years. As a dean, I sometimes sit in my office and think, if only this, if only that. Sometimes, often, in fact, that phrase turns out to be, if only we had 100 or 1,000 Carl Vacchettas. Because Carl...
Maybe not.
Yeah, I think so. Carl doesn't just give money to the college. He spends his time mentoring our students, helping them find jobs, teaching them here at the college on the intricacies of his practice specialty in government contracts. His financial generosity is certainly appreciated, but it doesn't even scratch the surface of what he means to this institution. And so, Carl, though I might wish for 100 or 1,000 of you, we've only got one, and we are so thankful for the one that we have. I want to give you this memory of the Ralph Brubaker investiture in the Carl Vacchetta Professor of Law. We'll turn it around.
Your turn. Great. Thank you all. Please, thank you. Good. Okay. Thank you. Please, thank you. Well, thank you all for coming. I'm most honored and pleased to be here. Before I make some other brief comments about my experience here, I should mention in the last couple days I've learned in speaking with John Colombo that we have some ties, and actually we may even be related. He wants to clone someone? Well, in any event, my mother's maiden name is Colombo, and I was asking him yesterday what his grandfather's name was, and his grandfather's name is Emilio Colombo, which is my grandfather's name. And I asked him where in Italy his family came from, Cugiano, and my mother's parents were born in Bernate Ticino, and the towns are literally 8 minutes apart. So, although Colombo is like Smith in the United States, we might be related somewhere. Thank you. Well, I'm very honored and pleased to be here to sponsor this professorship for a wonderful man, Ralph Brubaker. Like Ralph, I grew up in central Illinois, just east of here in Vermilion County. Like Ralph, I was valedictorian of my high school, Westville, Illinois, and he was valedictorian of Chrisman High School. My grandparents all came from Italy. Their big push was for a better life and for a life with some education. So education in my family was very important. My dad only went to seventh grade. My mom went to high school, but their big push was with their 3 kids to get them educated at a wonderful university. My brother and I went here. My sister went to Eastern. They stressed education, working hard, maybe doing well, maybe getting a scholarship, and with that, opportunities would flow. Thanks to the Army ROTC program here, I ended up during the Vietnam War on active duty as an Army JAG officer in a world I'd never heard of called government contract law. And thanks to the military and the career they gave me, I've been able to practice in this world for the last 40-some years in Washington, D.C. Thought I would come back to Vermilion County and practice law, but these opportunities brought me to Washington, and I never dreamed possible what my experience at this wonderful university and law school would be like, and I've made more money than I ever dreamed humanly possible. Certainly much more than my dad. In fact, I remember one time calling my mother, 1968, when I got out of the service, and I said to my mother, my dad by then had already died, and I said, Mom, you're not going to believe this. I'm a captain on active duty. I had been making $8,400. I said, guess how much money my law firm's going to pay me my first job? She said, how much? I said, $10,200. What do you think of that? Big pause. She said, your father never made more than $8,000 in a year in his life. So I started making more money my first year. And to all of you young people here, work hard. It's a great university. It doesn't get any better. I promised myself if I did well, I would give back, and that's why I do what I can. And I'm so proud to have Ralph Brubaker holding my professorship. Thank you all.
And now it's time to celebrate Ralph's many achievements as a renowned and prolific scholar, a treasured teacher, and an esteemed colleague. With 3 degrees from the University of Illinois, Ralph was an all-star Illinois student. After earning an undergraduate degree with bronze tablet university honors in agricultural economics and a minor in accounting, he passed the CPA exam before pursuing a joint JD MBA degree. He received his JD summa cum laude from the college in 1989 and was a member of the Order of Coif, a Harno Fellow, the recipient of the Rickert Awards for Excellence in Academic Achievement and in Legal Writing. He also served as an articles editor for the University of Illinois Law Review. After law school, he clerked for the Honorable James K. Logan of the United States Court of Appeals for the 10th Circuit. and after his clerkship, he practiced in the bankruptcy and corporate reorganization group of Squire, Sanders, and Dempsey in Cleveland, Ohio, where he gained extensive experience in large and medium-sized Chapter 11 bankruptcy reorganization proceedings, including prepackaged leverage buyout and mass tort bankruptcies. Then, the siren song of academics called. And Ralph returned to Champaign as a visiting assistant professor for the 1994-95 academic year. He went on to join the faculty at Emory University School of Law, where he taught courses in bankruptcy, bankruptcy procedure, corporate finance, business associations, and contracts, as well as serving as faculty advisor to the Bankruptcy Developments Journal. After 10 years at Emory, Ralph once again returned to his alma mater, joining the faculty here at the college in 2004. At Illinois, Ralph served as Associate Dean for Academic Affairs from 2006 to 2008, and as Interim Dean from 2008 to 2009. He has taught bankruptcy, bankruptcy procedure, corporate reorganization, civil procedure, contracts, and conflicts of law, and has served on and chaired countless college and university committees. Ralph's standing among the very top tier of bankruptcy scholars has been recognized in multiple venues. He is the editor-in-chief and a contributing author of the Bankruptcy Law Letter and serves on the editorial advisory board for the American Bankruptcy Law Journal. He has served on the executive committee of the board of directors for the American Bankruptcy Institute and the editorial advisory board for the American Bankruptcy Institute Law Review. In 2003, he was awarded the Editor's Prize from the American Bankruptcy Law Journal for his article of State Sovereign Immunity and Prospective Remedies, the Bankruptcy Discharge as Statutory Ex Parte Young Relief. In 2010, Ralph was inducted into the American College of Bankruptcy, the highest honor that can be conferred in the legal world of bankruptcy and insolvency, limited to those who have made exceptional scholarly and professional contributions in the field. And earlier this year, Ralph was elected to the American Law Institute, the preeminent scholarly organization in the United States dedicated to clarifying, modernizing, and improving the law. A professor at another institution provided what I think is the best summary of Ralph's research contributions this way. Brubaker writes about things that matter, and those professionals working in the trenches take notice. His work provides the theoretical, analytical, and normative foundations for the issues that he studies. But it's not just the research mission that Ralph excels at. The Associate Dean of the college, a job that I've held on occasion, reviews all of the teaching evaluations of our faculty every year. And I know personally from that review that Ralph also is a leader in our teaching mission. Students find him witty, engaging, easy to talk to, but tough and demanding in the classroom. And finally, Ralph is the consummate colleague, willing to take on committee assignments that no one else wants to do, helping to mentor young faculty, and doing all the unnoticed background tasks that have to be done for this institution to function at its high level. At the top of the pyramid as a researcher, a beloved teacher, and a highly respected colleague, Ralph, it is a privilege for me today to recognize your many accomplishments and bestow on you this honor of the Carl L. Vacchetta Professorship. At this time, will you please stand so that I may present you with the medallion marking your investiture. And I'm short. You're going to have to bend over.
Thank you very much, John, for that overly gracious introduction. Thank you all for being here. I'm especially grateful to have my very large and very supportive family with me here today. My wife, Rhonda, whom I met here at Illinois just before I started law school. She has cheerfully borne the brunt of my fascination, normal people might say obsession, with the law. Well, maybe not always so cheerfully, but she has always been my biggest supporter and most enduring font of aid and encouragement. She is the one person without whom I simply could not do what I do. It's a special treat to have both of her parents here, as well as her brother Vaughn, his wife Audra. They've always treated me as if I were their own son and brother, which means the world to me. So I'm so glad they could all be here. My mother and my brothers are all very special people. My mother and my brother Brad still live in Edgar County in the small farm town where I grew up, as Carl mentioned, in Chrisman, Illinois. And I'm thankful that they're both here today. I know that the three of us are especially remembering my father, Max, today and wishing he was still with us, able to join this celebration. The Brubaker children are plentiful, and they are the best thing that Rhonda and I have ever done. We're extremely proud of them, particularly proud of the fact that they are all carrying on the Illini legacy. Right? Allie, my daughter, is on her way to being a double Illini. She got her bachelor's in biochemistry from Illinois in 2012. She's now in her third year of medical school here on campus, taking time out today from one of her clinical rotations. Clinton is a senior here on campus, double majoring in Spanish and molecular and cellular biology. And our babies, the triplets, all started here as college freshmen in August. Calvin is in the Parkland Pathway program in engineering, and Philip and Riley are both biology majors in the College of Liberal Arts and Sciences, and they are being students today. There are many people to thank for their support and encouragement, and I know I won't be able to mention everyone by name, but I see so many friends, many of whom I can tell have traveled from far distances even to be here, so I appreciate everyone being here. As a triple Illini myself, it is especially meaningful to me to be on the faculty of my law school, for which I have so much affection and to which I will be eternally grateful for so many things, for lighting the intellectual spark in me as a law student, and some of the people who did that are scattered around this room, for giving me my start in law teaching as a young visiting assistant professor back in the 90s, and now for giving me such a wonderful professional home where I can constantly do what I love, explore ideas with my students, with my colleagues, and in the larger national and international dialogues in which everyone on this faculty participates simply because they are law professors at Illinois. I have fantastic students. I have fantastic colleagues. This is a wonderful place to teach law. This is a wonderful place to study law and to engage as a scholar. And much of the credit for why this is such a special place with such an invigorating intellectual atmosphere goes to the visionary leaders of the law school, whom I would like to mention and especially thank for their support of my work and for everything that they've done to make Illinois such a great law school. Dean Heidi Hurd and Dean Charles Tabb, both of whom I had the pleasure of serving with, serving for, right, as Associate Dean, Dean Bruce Smith, and now Dean John Colombo. The law school has benefited tremendously from the wisdom and leadership of all of my Illinois deans, and I count myself as an especially grateful beneficiary. The law school is also blessed with wonderfully talented administrative personnel who are the only reason we can do events like this one and things like this weekend's homecoming festivities. And they always do such a wonderful job. Carrie Turner, Heather Ball, Melissa England, Carrie Mae Borich in particular did their usual brilliant work in planning this investiture. In the middle of homecoming weekend, no less, as if they didn't have anything else to do in the middle of homecoming weekend. And I especially want to thank my assistant extraordinaire, Mary Parsons. My professional life commitments and schedule and travel and conferences and lectures and publications, etc., all those things get done with some semblance of order and efficiency only because of the tremendous order and efficiency and professionalism that Mary brings to bear on every aspect of my professional affairs every day. With Mary, it is like there are 2 or 3 of the Maryless me. So thank you very, very much, Mary, for everything you do. I also want to quickly mention 2 of my faculty colleagues. Unfortunately, neither of them could be here today. Bob Lawless, who was my law school classmate here and who shares my scholarly interest and expertise in bankruptcy law, and whom we will be celebrating as the newly minted Max Rowe Professor very, very soon. And Charles Tabb. Charles was both my and Bob's bankruptcy professor when we were law students here. And the 3 of us have always been very close professional collaborators, and even more so now that we are all reunited back at Illinois. I appreciate both of them as friends, as colleagues, as collaborators very, very much. And the person I appreciate more than anyone else in connection with today's event is Carl Vacchetta, my very good friend who is also a very close and cherished friend of the law school and a very close and cherished friend of the university. As Carl mentioned, we have a lot of ties. Like Carl, I am extremely proud to have multiple degrees from Illinois, including our law degrees. Like Carl, I am extremely proud to be an Illinois native from East Central Illinois. Both Carl and I grew up in small town, rural East Central Illinois, the same neck of the woods, as they say. Carl hails from Westville in Vermilion County, which is just a stone's throw away from my hometown of Chrisman in Edgar County.
You probably have more taverns.
Well, what I had heard when I was growing up is that Westville had more taverns per capita than any other town in the state of Illinois. So I think that's probably true. And the connection that's less obvious is we both love Steak and Shake. Less obvious for Carl, of course, than for me, since I tend to wear my Steak and Shake around my midsection. But Carl never seems to gain a pound. So being named the inaugural Vacchetta Professor is especially meaningful to me. It's a fitting tribute to Carl and all he does for the law school. And for me, it carries an even more private and personal symbolism about my and Carl's mutual bonds of loyalty, fondness, affection for our native Illinois homes, for our university, for our law school, and for our Steak and Shake. Right. Perhaps we should call it the Steak and Shake Professor of Law. But, as a token of my gratitude to Carl, and in commemoration of my great good fortune in being named the first Vacchetta Professor, I also have a gift for Carl. So Carrie, if you would, show us what we've got for Carl. A new car. No. So what this is a print from an 1876 atlas of the state of Illinois, which was published just a few years after the founding of both Chrisman in 1872 and Westville in 1873, The top sketch, as it happens, is of a homestead in Carl's native Vermilion County, circa 1876, and the bottom sketch is a homestead further south in Edgar County, where I'm from. So, Carl, thank you very much. And for those who are interested, the university library's very fragile copy of the Atlas volume from which that print was made will be on this table during the reception if you'd like to see it. So it is customary on these occasions for the recipient of an endowed position to share from his or her scholarly work. Luckily for all of you, time constraints will force me to be very brief. But I would like to give you a flavor for the kinds of issues I think and write about and why I find them interesting and important. In law school, I became fascinated by bankruptcy law, of all things, perhaps because my background in accounting, finance, economics, and of course I had a good teacher, Charles Tabb. But it just sort of intuitively clicked with me that in a market-based economy that prizes minimal regulation, that prizes vigorous competition, and that heavily relies upon debt financing, we have to have a reliable system for dealing with financial distress. That the largely American ethos of maximizing the economic opportunities of businesses and individuals with maximum flexibility, minimal interference from the government, that inevitably brings increased financial risk, both for businesses and for individuals. Ours is a market system, or for better or worse, that permits financial failure by businesses, that permits financial failure by consumers. And as we've seen with the recent Detroit bankruptcy, it even permits financial failure by governmental entities, right? So we have to have a comprehensive system for dealing with that financial failure. And once you start delving into the details of sorting out the financial affairs of overburdened individuals, overburdened businesses, overburdened governments, you discover that it's a very sophisticated and relatively complex system. There are lots of competing interests that have to be accommodated, lots of moving parts in the operation of the system, which I guess appealed to my intellectual curiosity. There are just endless number of interesting conceptual, theoretical, practical puzzles to grapple with. And what I also came to appreciate more and more, especially when I was a practicing attorney doing, as John mentioned, Chapter 11 corporate reorganization work, is the immense significance of the fact that bankruptcy is administered as a judicial process through the federal courts. So while I have studied and written about lots of different aspects of the bankruptcy system, for example, Charles Tabb and I have recently written together about the Chrysler and GM reorganizations. Heidi Hurd and I have an ongoing collaboration in which we proffer a moral, philosophical justification for discharging the debts of hopelessly overburdened individuals. The aspect of bankruptcy law that has most intrigued me and that has fueled my scholarship and my scholarly work more than any other is the federal court's perspective, that bankruptcy is administered as a judicial process in the federal courts, which is not an inevitable way to organize an insolvency system. In fact, since the 1970s at least, there have been many proposals to convert bankruptcy, especially consumer bankruptcy cases, to more of an administrative agency process, sort of the way Social Security benefits are administered. And that idea, on a fairly regular basis, tends to get resurrected in the academic literature. And there are some academics who even dream of a world in which bankruptcy or insolvency, especially corporate insolvency, is entirely self-effectuating, right, without any court involvement at all. And our late great colleague Larry Ribstein would be someone who was pretty firmly in that camp. Yet, bankruptcy endures as a judicial process, and in fact, the bankruptcy system far and away is the largest part of the federal court system. Right? Just to give you an idea, there were nearly 1.2 million bankruptcy cases filed last year, and that is more than 4 times the number of civil lawsuits that was filed last year, that were filed last year in the federal district courts. Of course, most of those 1.2 million bankruptcy cases were filed by individual consumer debtors, and only 9,800 of those 1.2 million bankruptcy cases were Chapter 11 reorganization cases, which of course are the kinds of cases that we tend to associate with mega corporations that file bankruptcy. Right? That is a very, very small sliver of the 1.2 million bankruptcy cases, right? And many of those Chapter 11 cases are not filed by mega corporations. They're filed by small and medium-sized business. In fact, last year, there were only 71 companies with publicly traded stock that filed bankruptcy. Right? Even though the number of cases filed by those very large companies is very small, right, they are a big deal. Right? They represent, right, of the 1.2 million right, bankruptcy cases, they represent the vast majority of the total assets that are administered in bankruptcy. So just again, to give you a sense, of the 25 largest Chapter 11 cases that were filed last year, they totaled almost $28 billion in assets. They had annual sales of over $15 billion, and they had over 60,000 employees. So the federal court's bankruptcy docket is large and important, both in terms of its financial significance and in terms of its impact on real people. More Americans will have direct contact with the bankruptcy system at some point during their lives than any other part of the federal court system. Right? The fact that bankruptcy is a judicial process is really just another enduring legacy of the fact that we inherited our legal system from England. Okay? Bankruptcy was administered through the courts in England, and then in our colonies and states before the founding of the Republic, it was also a judicial process. And the judicial nature of the bankruptcy process that we inherited from England figured very prominently in the reasons why the framers of our Constitution thought it was necessary to give the new federal government a power to enact bankruptcy laws as federal law. There were and are limits on the powers of the courts of a state. So, for example, if a debtor were to file for bankruptcy relief and get a bankruptcy discharge in state court, right, and let's say it's in Pennsylvania, right? Well, would that discharge decree from a Pennsylvania court bind New York creditors? That was an active and extremely consequential question at the time of the founding of the Republic and the writing of the Constitution, because the institution of imprisonment for debt was still very much alive and thriving. So if the Pennsylvania discharge decree could not affect out-of-state New York creditors, if that Pennsylvania debtor thereafter happened to go to New York, the New York creditors could still have him arrested and thrown in jail. Right? So the framers of the Constitution concluded Congress has to have the power to pass uniform national bankruptcy legislation. And the settled understanding at the time that bankruptcy was a judicial process very much informed the framers' understanding of what they were doing, what they were authorizing, when the bankruptcy clause was inserted into Article 1 of the Constitution. In fact, there are very plausible constitutional theories of Congress's bankruptcy power under the Constitution. that the judicial nature of bankruptcy is of the essence of Congress's bankruptcy power to such an extent that the Article I bankruptcy power itself, right, is an authorization to give the federal courts jurisdiction over all sorts of disputes that would otherwise have to be resolved in state courts. Right? And the corollary is that the judicial article of the Constitution, Article 3, just does not matter with respect to bankruptcy because bankruptcy has its own independent authorization for the exercise of federal judicial power in the Article I bankruptcy power. Right? And in fact, I have probably articulated that particular constitutional theory more fully in my writings than anybody else in sort of teasing out all the various implications of that theory, which is ironic because that is a theory with which I vehemently disagree. It is wrong, right, for reasons that will become clear shortly. But one of the most striking things about the federal judicial power in the context of bankruptcy proceedings is that it is indisputably a very aggressive, very sweeping, extremely potent exercise of judicial power. And of course, from their inception and over the course of our history, the federal courts have proved vitally important in protecting federal rights, but they've also been something of a lightning rod, surrounded by an atmosphere of lingering suspicion and distrust that they might prove much too powerful, too intrusive, and their power might be subject to abuse. And of course, that concern was especially prominent in the founding era. So the Constitution has a whole series of provisions that limit the powers of the federal courts and that insulate them against improper influences across a lot of different constitutional dimensions, like individual liberty and the importance of protecting individual citizens against unreasonable exercises of the federal judicial power, like federalism and the idea that the domain of the federal government is limited and everything else should be handled by the states and not the federal government. So, for example, the kinds of disputes the federal courts can hear are limited in the Constitution. And there's also a separation of powers dimension in the constitutional checks and balances among the branches of the federal government that protect the independence and integrity of the judiciary so that it is not co-opted by the political branches in its even-handed administration of justice. And there's actually a case pending in the Supreme Court right now dealing with that separation of powers and judicial independence dimension of the federal bankruptcy courts. Well, one after another, as you study all of the various limitations on the federal judicial power and how those limitations apply to bankruptcy proceedings, at least on the surface, those limitations just do not seem to apply as forcefully, and in some cases, maybe they don't apply at all, because the federal courts, in the context of federal bankruptcy proceedings, do have much more expansive jurisdiction, do have much more expansive powers to do all sorts of things that they just can't do in the other kinds of cases they hear. And that has led many to conclude that bankruptcy is just somehow different than all other exercises of the federal judicial power. So it's very, very common for judges, for lawyers, for academics to generally view the judicial power in bankruptcy as sort of sui generis, sort of a pervasive, all-purpose bankruptcy exceptionalism theory of a piece with the self-contained Article I bankruptcy power theory that I just mentioned a few minutes ago, right? That the Article I bankruptcy power is, in its essence, a federal forum power, that the Article I bankruptcy power contains all of the authority for federal courts' powers in bankruptcy cases, and whatever constitutional limits there are on federal courts' powers in bankruptcy cases have to come from the scope of the bankruptcy power itself, right? And the Supreme Court at times has also tended to buy into that kind of bankruptcy exceptionalism view of the judicial power in bankruptcy, that views bankruptcy as somehow fundamentally different than the rest of the federal court's docket, such that what we regard as first principles regarding federal courts' powers and the limits on federal courts' powers just don't apply to bankruptcy proceedings. As a result, first principles regarding the scope of federal bankruptcy courts' powers are still extremely contested and extremely unsettled over 200 years after the enactment of the first bankruptcy statute. So much of my scholarly work has been to try to systematically find and articulate first principles regarding the scope of federal bankruptcy courts' powers. And while I am usually swimming against the tide a bit or a lot, what I think I've discovered and what I've tried to demonstrate in my work over and over again in one context after another is the bankruptcy is not sui generis. It is not fundamentally different from other exercises of the federal judicial power. Bankruptcy is inherently more complex than general civil litigation, but when you break down that complex bankruptcy process into its component elements, the bankruptcy process is very easily, right, and I think best understood and explained in exactly the same way that all other aspects of federal courts' powers are understood and explained, using conventional, relatively settled constitutional and non-constitutional theories and explanations about the source, scope, limits on federal courts' powers. So my work contends that there are discernible limits on federal bankruptcy courts' powers, the same limits that are generally applicable to the federal courts. Of course, how those limits apply to bankruptcy can be complicated because the bankruptcy process itself is so complex. But the limits themselves are fully applicable. And oftentimes, notwithstanding the complexity of the bankruptcy system, are fully applicable with elegant simplicity that the complexity of the bankruptcy process just sort of obscures. And of course, the reason I favor that approach, that bankruptcy is not sui generis, is because if the limits on bankruptcy courts' powers come from nowhere other than the constitutional limits on the bankruptcy power itself, I fear there may be no limits on bankruptcy courts' powers, because the parallel development is that the Supreme Court has never articulated in any precise manner exactly what it is that the Article I bankruptcy power authorizes. And in fact, the Supreme Court's most famous, most cited statement about the Article I bankruptcy power is this. Quote, "The subject of bankruptcies," which is the phrase the Constitution uses in the Bankruptcy Clause, "the subject of bankruptcies is incapable of final definition." Well, if that's all we have as a limitation on federal bankruptcy courts' powers, of course, that is a recipe for limitless federal court power in bankruptcy proceedings. And how are we doing on time, John? So this is the point in the lecture where you decide whether you're going to do the radio version of the lecture or the dance version of the lecture. And since I always hate the dance version because it just goes on and on and on and it never stops, I will do the radio version. This impetus to regard federal bankruptcy proceedings as different than federal courts' powers in other cases is of relatively recent origin, and I think there's some easy explanations for it. In the 19th century, the first federal bankruptcy statute was enacted in 1800. This sort of bankruptcy exceptionalism attitude just did not exist. Perhaps because there was relatively much less federal law than there is now, and the federal judges, therefore, perhaps understood federal bankruptcy law better than do the modern generalist federal judges who have so many other federal laws now to occupy their time and attention in a very pressing manner, including lots of federal criminal laws that they have to, right, vitally important that they know what they're doing there. And I think you also see the same phenomenon amongst modern academics, right? Those who specialize in the study of federal courts, right, and the source and scope and limits on federal courts' powers, they tend not to really be interested in bankruptcy, which, of course, makes the bankruptcy exceptionalism thesis very convenient and very attractive, because if that's true, then they don't have to know much about bankruptcy. They can leave it to those who study and think about bankruptcy law, which they are not interested in, because let's face it, bankruptcy is boring and hard, right? Not true, right? Bankruptcy is endlessly fascinating. Like tax, yeah. No, not like tax. The problem, though, with the federal courts scholars sort of ceding the field to bankruptcy scholars, of course, is that those who are interested in bankruptcy law don't tend to know much about federal courts law. They tend to be corporate law people and commercial law people and consumer protection people, which also makes the bankruptcy exceptionalism thesis convenient and attractive to them, right? Because if it's true, they don't really have to know anything about federal courts law. So I guess the only really truly unique thing about my scholarly work is that I am one of the few people on the planet that is interested in both bankruptcy law and federal courts law, which, as you would guess, makes me extremely popular at parties. But as a scholar, by sort of exploiting this neglected but very, very important link between bankruptcy law and federal courts law, not only have I discovered that bankruptcy fits very nicely within the conventional understandings of federal courts' powers, it has also allowed me to validate conventional, tried and true federal courts theories about the source, scope, and limits of federal courts' powers. Right? So in addition, right, because bankruptcy does indisputably require such an aggressive, sweeping, very, very potent exercise of federal jurisdiction, federal powers in bankruptcy cases, there is a tendency by those federal court scholars that are inclined to try to find ways to expand federal courts' powers in general beyond what conventional theory would permit, to point to bankruptcy and say, yeah, but look at bankruptcy and look at all the things they do in bankruptcy that we can't do in regular cases that conventional theory doesn't seem to validate. That must mean conventional theory is too narrow, too restrictive on federal courts' powers. My work also challenges that strand of federal court scholarship, right, by demonstrating, I believe, that conventional theory is not too restrictive, because bankruptcy does indeed fit very, very comfortably within the confines of conventional federal courts theory. And I know that all of that is extremely abstract, and if we had more time, I could give you lots of concrete examples of how all that abstract theory plays out in actual things that federal bankruptcy courts do today. I could shock your socks off on the things they do and the things that litigants ask them to do. I could teach you a whole course in bankruptcy litigation and procedure, which, as it so happens, I do. Teach an entire course in bankruptcy litigation and procedure, offered next semester for any students whose interest has been piqued. I am paid a commission on the number of students that, no, I wish I were. For everyone else who's not going to take my bankruptcy procedure course next semester, I will have to leave it there. And thank you for your time and attention and for the honor of this occasion. Thank you.
Great job.
And now I would like to invite you to join us in the Pierre and Sarah Peterson Pavilion for a reception in Ralph's honor. You can eat, you can talk to Ralph. He can explain to you more about these things about bankruptcy law, which will keep us busy at least until 2 o'clock this afternoon. Thank you all very much.